Thank you very much, Mr. Chair. I'm here today to present Senate Bill 934, a bill to provide justice to survivors of conversion therapy by allowing them more ability to seek compensation through malpractice claims. Straight up, conversion therapy is quackery. It is psychological torture. You can't change someone who is LGBTQ into not being LGBTQ. All major medical associations agree that sexual orientation and gender identity are immutable characteristics, and that so-called conversion therapy is fraud that harms patients. Research shows that conversion therapy does not change a person's sexual orientation or gender identity, but that it is associated with serious harm, including increased likelihood of depression, suicidality, lower educational attainment, and economic insecurity. In 2012, California became the first state to ban licensed mental health professionals from engaging in conversion therapy. This ban has served as an essential bulwark against that practice. Since California took the first step, 29 other states have also acted, either legislatively or via executive order. However, last week, the Supreme Court put that ban, at least potentially, in legal jeopardy by directing lower courts to subject the Colorado youth conversion therapy ban by subjecting it to so-called strict scrutiny, which is a very, very high level of constitutional scrutiny, essentially saying that psychological torture of children is somehow free speech. But agree or disagree, that was the Supreme Court's ruling, and that's the standard to which these laws will be subjected. It is critically important to understand that California's law was not part of the Supreme Court case. It was a Colorado law, but there have already been rumblings of a legal challenge to California's law. And so here we are. It's also important to understand that the Supreme Court ruling, the majority opinion by Justice Gorsuch, specifically said that malpractice claims or a malpractice cause of action is different than a conversion therapy ban. And that was important, and that's what we are doing here today, considering a bill relating to malpractice, not to a ban. So right now, the existing statute of limitations for a malpractice claim, 3 years, is insufficient to deal with the long-term trauma from conversion therapy, particularly of young people. And so this bill does two things. It extends the statute of limitations. If the survivor was under the age of 18 at the time that they were subjected to conversion therapy, they could bring a claim up until the age of 40. If the survivor was over 18 years old, then they have 10 years. Or a survivor may bring a case within 5 years of discovering injury or illness due to sexual orientation or gender identity conversion therapy. SB 934 also clarifies the role that expert testimony plays in scientific evidence, making sure that we are using the best expertise in scientific evidence in adjudicating these malpractice claims. Colleagues, we know that LGBTQ people are under assault in this country, and the common denominator in these attacks, whether from the Trump administration or from red states, is the attempted erasure of our community. In so many ways, they want us to just go away, to go back in the closet, or just not to exist at all. And conversion therapy is absolutely a part of that. And like many people, although I am very fortunate that I was never subjected to conversion therapy, I thank my parents for being good, decent people who would not do that to a child. I know so many people who were sent to conversion therapy as children. They had no choice in the matter. They were sent there, and they were subjected to what can only be described as torture. And so with that said, I ask for your aye vote with me today to testify is Ryan Kendall, a survivor of conversion therapy and civil rights litigator in Southern California, and Sky Inararity, a licensed marriage and family therapist with 12 years of clinical experience. And also here for technical support if needed, Chris Stoll, a senior staff attorney at the National Center for LGBTQ Rights. I ask for your aye vote.
We have a quorum. So, Committee Assistant Porter, or maybe Chief Counsel Estrada, if you would call the roll for purpose of establishing a quorum.
Sure. For the purpose of establishing a quorum, Umberg.
Here.
Umberg here. Nilo.
Here.
Nilo here. Allen. Ashby. Caballero. Here. Caballero here. Durazo. Here. Durazo here. Laird. Reyes. Here. Reyes here. Stern. Valadares. Wahab. Here. Wahab here. Weber Pearson. Wiener.
Present.
Wiener present. You have a quorum.
All right, thank you. The floor is yours.
My name is Ryan Matthew Kendall. From the ages of 14 to 16, a California licensed therapist abused me using the practice of so-called conversion therapy. Using only words, Joseph Nicolosi destroyed my sense of self, leaving me, as a child, convinced that I was unworthy of love and defective simply for being gay. I still live with the damage that caused me. It's why I'm here today, asking you to protect others. Not only did Nicolosi abuse me using conversion therapy, but he also fostered an environment where my parents were free to abuse me in ever more extreme ways to stop me from being gay. Even though he was a mandatory reporter, and even though I complained about this abuse to him, he never acted to protect me. To escape conversion therapy and my family's abuse, I filed dependency and neglect charges against my parents and had the state revoke their custody. But even after getting away, I spent more than a decade of my life suicidally depressed, at times unhoused, and I abused drugs in an attempt to kill myself. I failed out of or withdrew from college 5 or 6 times. My life was a desperate struggle for survival. At no point during that period or for years afterwards could I have brought a lawsuit against the man who abused me and destroyed my life. Conversion therapy robs LGBT youth and adults of their agency by convincing them, as I have heard from youth countless times, that they are somehow at fault for the situation they are in or for being who they are, or, as happened with me, that we are defective and undeserving of care. None of those things are true. Conversion therapy is a medical fraud that kills children. It harms everyone who comes in contact with it. It tears families apart, and that's if you survive. Today, you have the opportunity to give everyone harmed by this vile practice a meaningful chance at justice. I can think of no better use of your votes than that. California has always led the way on protecting LGBT youth from this vile practice, and California can lead the way again today. I ask you to support this bill.
Thank you very much. Thank you. Next witness, please.
Good afternoon, Chair, members. My name is Sky Inararity. I am a citizen of the Ione Band of Miwok Indians, and I am a licensed marriage and family therapist here in California, where I have practiced for 12 plus years. I've provided services across outpatient, residential, private practice settings, and I have provided direct services to queer, two-spirit, LGBTQ plus, and Indigenous clients throughout my career. And I'm in support, strong support of SB 934. From a clinical standpoint, I want to be very clear. Conversion therapy is not a legitimate therapeutic practice. It's not a legitimate therapeutic intervention. It has no basis in evidence-based practice. Every major medical and mental health organization has condemned it as ineffective and unethical. In my 12 plus years as a clinician, I have never seen credible clinical data supporting that sexual orientation or gender identity can be safely or successfully changed through therapeutic means. What I have seen repeatedly is harm. Survivors present with significantly elevated rates of major depression, PTSD, suicidal ideation. Many meet criteria for complex trauma, characterized by deep shame, identity disturbance, and difficulty forming secure attachments throughout the entirety of their lives. These are not abstract findings. These are the diagnostic realities in which I've assessed and treated in my practice. In my clinical experience, the full impact of conversion therapy often does not emerge until years later. Survivors frequently lack language or psychological safety to identify what has happened to them as abuse. They may spend years in therapy long before they can even name what has happened. Current statutes of limitation often expire long before a survivor is clinically ready to come forward. This mismatch between legal timelines and psychological healing denies survivors any path to accountability. SB 934 aligns legal accountability with clinical reality. It ensures survivors have a meaningful window to seek justice and hold providers accountable for practices that my profession has unanimously.
Thank you very much. If you could wrap it up, I assume you urge an aye vote.
As a licensed mental health clinician, I urge your support.
Thank you.
Thank you.
All right. If you're in support of SB 934, please approach the microphone. Give us your name, your affiliation, and your position.
Christopher Stoll with the National Center for LGBTQ Rights, here in strong support of this important legislation.
Thank you.
Craig Polster on behalf of Equality California, proud co-sponsor and strong support. Also here on behalf of several co-sponsors who could not be here today, the Trevor Project, Lambda Legal, Alliance for Trans Youth Rights, and Trans Family Support Services.
Thank you.
Anuradha Gupta, President of PFLAG Danville San Ramon Valley Chapter. On behalf of everyone in my chapter, PFLAG San Francisco, PFLAG La Morinda, PFLAG Clayton Concord, PFLAG Fremont Tri-Cities, PFLAG Tri-Valley, PFLAG Oakland, East Bay, PFLAG San Jose Peninsula, PFLAG Los Angeles, in strong support of SB 934, request you to pass it. Thank you.
Thank you.
Hello, Mary Moyle. I'm with the Sacramento chapter of PFLAG, and we urge and I vote on this. Thank you.
Thank you.
Hello, I am Lisa Kanazawa. I am a California licensed occupational therapist. I am here with PFLAG Danville, San Ramon Valley, and I am here in strong support of SB 934.
Thank you very much. All right. Seeing no one else approach the microphone, let's turn to the opposition. If you're opposed to SB 934, please come to the microphone.
Good afternoon. My name is Johnny Skinner. I'm here representing GenSpect. When I was young, I was a feminine child, and I discovered trans influencers online. They said, change your body and your life gets better, don't and it gets worse. Or as my doctors told my mom, I would commit suicide. The medical and mental health providers didn't bother to ask why I felt the way I did. They poisoned my body with blockers and hormones, arresting my puberty and messing with my development. The result? I'm a 23-year-old gay man who's never had an orgasm and may never experience one. Let that sink in. I was rendered anorgasmic because once you say you could be trans, that's it. Full stop. No exploration as to why is allowed, even if you are a struggling kid. The former president of WPATH, Dr. Marcy Bowers, a California surgeon who had performed the surgery for Jazz Jennings at 17, admitted on video that puberty blockers followed by cross-sex hormones results in no orgasms and stunted genitals. SB 934 guarantees that more people will end up like me, the walking but wounded. I could have been spared all of this if any of my therapists would have explored why I felt dysphoric, but they never did. They only led me to hate my body more. The Supreme Court just ruled in a rare bipartisan decision that laws like this are unconstitutional viewpoint discrimination. This bill is an attempted workaround that will be used to silence therapists who could have helped me avoid the irreversible harms to my body and the loss of my sexual function, as is the same for many others. So today I ask you to extend some empathy to survivors like me and vote no for this bill. Thank you.
All right. Others in opposition, please approach.
Hi, Laura Haynes. I'm a Democrat, an atheist, and a CASA for foster youth since 2015. This bill forbids challenging LGB or TQ identities, even if that's why the client sought therapy. Both are made untouchable, so normal questions that might provoke a changed mind could later be deemed conversion. But conversion therapy refers specifically to abusive practices used in the past to attempt to change sexual orientation and rightly long ago made illegal. Here, conversion is used to imply that trans is an innate and permanent condition that only violent conversion could possibly change. But historically, over 90% of kids who once strongly rejected their sex naturally outgrew this notion via puberty, 2/3 of them gay as adults. Reaching self-acceptance is not conversion. Change is not conversion. Realizing you're autistic is not conversion. Remember, gender is considered fluid, not fixed, as detransitioners continually prove. How can a therapist determine if autism, OCD, or trauma is at the root of a client's sex self-rejection if they're walking on eggshells not to jostle trans? What if the kid is not trans? Imagine a 12-year-old girl molested at summer camp who comes home insisting she's trans and wants top surgery. This bill would have a therapist affirm as identity a trauma response. That's absurd. Trans ID people have a very high number of other mental health disorders. If ethical therapists are effectively gagged with relevant topics placed off limits, who will help them? I urge you to vote no.
Thank you. Those in opposition to SB 934, please approach the microphone. Give us your name, your affiliation, and your position.
Good afternoon. Matthew McReynolds, constitutional attorney with Pacific Justice Institute, in opposition, and happy to answer any technical constitutional questions the committee may have.
All righty, thank you.
Ariane Geringer from LGB, that is Lesbian, Gay, and Bisexual Alliance USA. Opposed to this bill, please don't conflate sexual orientation with gender identity.
Thank you.
Nicole Young, Placer County resident, in full opposition of this bill.
Greg Burt with the California Family Council, in strong opposition. Thank you.
Sarah Kim with TV Next, in strong opposition to 934.
Lisa Disbrow from Contra Costa, Moms for Liberty, and informed parents of Contra Costa parents, in strong opposition. This is not conversion therapy.
Thank you very much.
I'm Bev Talbot, a lesbian with the LGB Courage Coalition, telling gay and gender nonconforming kids that they are born in the wrong body and must become the opposite sex is the ultimate conversion therapy.
All right.
Please vote no.
All right.
Romy Mancini, I'm a San Francisco resident, a lesbian, a former attorney for the ACLU Lesbian and Gay Rights Project, and I strongly oppose this bill.
Thank you.
Barbara Walker from San Francisco Bay Area, mother of 3, member of Women Are Real, in strong opposition. Thank you.
Thank you.
Rachel Bordoli, San Francisco resident, registered Democrat, member of Democrats for an Informed Approach to Gender, Women Are Real, parent strongly opposed to unevidenced treatment of gender-confused kids. I strongly oppose this bill.
Elizabeth Cronin, lifelong Democrat from San Francisco, member of California Teachers Association for 35 years, strongly oppose.
All right, thank you.
Annalie Augustine here on behalf of the Civil Justice Association of California. We are respectfully opposed for very specific civil procedural issues. Thank you.
Thank you.
Joshua Coleman from Roseville, California, and I oppose the bill.
Good afternoon, members. Kasia Williams, California parent, in opposition to the bill. Thank you.
Thank you. All right, anyone else opposed to SB 934? Please approach. Seeing no one else approaching, bring it back to committee for questions, comments, questions? No questions. All right. Senator Caballero.
Well, I thought I understood what this bill was doing. First, let me thank everybody who came here to testify today about your personal life experiences. They help inform our decisions, and I heard a lot of pain, and I want to acknowledge it and basically say I don't think any one of us up here want to see the kind of harm that was done as children. We just don't want to see it. That's not the right thing. I am interested in protecting children, and I think there are methods that have been used in the past that shouldn't continue to be used. So that's what leads us to today. Trying to figure out how to articulate the question that I have for you, because it seems to me that on the one hand you have, as I understand the bill, it was to focus on a therapy that is harmful and that has been discredited by every single mental and physical health organization. And we've taken action on that before, and this is in my mind a clarification of how we want that kind of therapy not to be utilized in the state of California. But I'm hearing other concerns raised, and I was wondering if you could articulate the
Sure.
where the missing link is, I guess is the best way to put it.
Yeah, so what this bill covers is conversion therapy, also known as change therapy, where a person has a certain sexual orientation or gender identity, and a therapist says, I'm going to change you from this gender identity to this gender identity. I'm going to change you from this sexual orientation to this sexual orientation. That has been completely discredited, and that's what the bill covers. It does not in any way prohibit people going to see a therapist to explore their sexual orientation or their gender identity. That has always been allowed. It'll continue to be allowed. And so this notion that no one can even talk to a therapist about it is not true. But when you have a therapist who's like, you identify as this gender, I am going to change you to that therapy, or to that gender, excuse me. Or you identify as this sexual orientation, I'm going to change you to that sexual orientation. That's what the bill covers.
And just so that I can be very, very clear about this, we're not talking about drug therapy.
No.
I mean, and we're not talking about sex changes.
No.
And we're not talking about yes. So I guess those were the two big.
Yeah, this is about a mental health professional providing therapy. That's what this is not about physical medical interventions. That's not what this is about.
Okay, thank you very much. I appreciate that.
Thank you. Senator Reyes, you had a question?
Thank you. And I also want to begin by thanking Ryan for giving your testimony. I'm sorry that you went through that. And you clearly were not the first. You won't be the last. And the fact that you were here to talk about it, I think, is going to give a lot of courage to others who have gone through the same thing. And if this bill passes and is signed, then the statute of limitations, which is what we're talking about, is something that would be extended to allow that opportunity to seek recompense for the harm that was caused to you. Now, I think, like my colleague, Senator Caballero, I heard a number of things. Somebody said, reaching self-identification is not conversion. So if somebody comes in and wants therapy to figure out who they are, that's not considered conversion.
Yes, that's correct. If someone's exploring and they want to talk to a therapist about it, they'll be able to continue to do so, and the therapist will be able to continue to provide that therapy.
Somebody else said this bill would require therapy to affirm what somebody comes in with, but that is with the identity they come in saying.
Right. What the bill does is it applies if a therapist says, you're coming in, you're saying you're gay, I am going to make you straight, or you are telling me you identify as a woman, I am going to convert you to identify as a man. That's what the bill addresses, the attempted conversion.
Somebody else said the therapist should have asked why I was dysphoric as opposed to beginning to give me treatment. This has nothing to do with, somebody could come in having issues and the therapist has to treat them for the issues. Is that correct?
Yeah, when someone is transitioning, which when you get hormones or puberty blockers or surgery, and by the way, the vast majority of trans-identifying kids do not even get a diagnosis, let alone physical treatment. But for the ones who do, that goes through an accepted medical process in terms of determining what's appropriate, what's not appropriate. But it's different than you come in identifying one way and the therapist saying, I'm going to convert you to identify a different way, which is what the bill is about.
Finally, somebody said we need to help children who, gender-confused kids. What does this have to do with gender-confused kids?
I don't, in terms of who said that and what they mean by it, there are people who say that transgender people don't exist and that they're all just confused, and that any child who identifies as transgender is confused. A lot of people would disagree with that, including many in the medical profession, and so that's their perspective. And for a child or an adult or anyone who is who actually says, I'm exploring my gender and I want to talk to someone about it, this bill does not in any way impact that.
So that I am clear, like my colleague, this has to do with those who have been harmed by conversion therapy. Yes. The statute of limitations has limited their ability to seek recompense for that harm, and this bill extends that statute of limitations so that they are able to, through evidence, show the harm that they have suffered, as Ryan has so properly described.
That's correct.
Thank you.
Thank you, Senator.
All right. Yes, Senator Ashby.
Thank you. I guess I want to align my comments with both of my colleagues who have spoken. I was watching from my office and wanted to come down because I wanted to ask you. The comments don't really align with the bill. Can you help me understand this? I mean, when I read through this bill is really about statute of limitations.
So there are, and we see it in this committee a lot, there are people who believe that trans people don't exist. There are people who believe that a child can never be transgender. There are people who believe that. There are people who dispute physical care for gender-affirming care, particularly physical gender-affirming care for people, and particularly for children. And that is, they're entitled to their views. What this is in the transgender context, which is what most of the public comment was about, is if, let's say you are a parent, let's say a parent has a 15-year-old who was born identified as a girl and now identifies as a boy, and if the parent says, I'm going to send you to this camp where a quote-unquote therapist is going to convert you to being a girl through therapy, that would be subjected to this bill. That is very different than a lot of what we were hearing about today. This is about when, and again, the bill applies to adults as well, but in the child context, when a child is like, I'm gay, I'm trans, and the parent says, I'm going to make you not gay or trans by sending you to that person who's going to inflict severe harm on you.
I hear that, and my understanding of this bill is that this is really just a statute. This is like as Senator Caballero said, we've already legislated in this space. This bill is really cleanup relative to the issue in, I think, Colorado, went to all of that. What is your trajectory here? Where do you go after Judish?
It's, I believe, single referred, so it'll go to appropriations.
Appropriations. And you still have the other half of the House to go through? Or?
Yep.
Yeah, I mean, you are an author who works really hard on your bills and you take on tough topics. It sounds to my ears like what I am reading in this bill, what we all came to this committee for a variety of reasons. My legal background sees this, thinks that the comments are a bit disconnected with what the bill actually does. So my hope is that in your time between now and the time that you finish this process is that you'll work with folks so that people understand the impacts of this actual language that you have in front of us.
Yeah, we always work with a lot of people. It's hard to work with people who say that a certain group of people don't exist.
Yeah, no, I hear you on that. But there were also clearly some people in the group who were speaking that for whom I don't think that was their position, but also I think would be natural allies normally to this effort. So that's just what my ears heard. I'm going to support the bill. I'm going to support the effort moving forward. I'm just hopeful that there will still be some additional dialogue so that everyone can kind of be in the same place on what the bill does. My understanding of this bill, I think, is righteous. So I'm just hopeful that there will be some greater understanding as you go through that process. And I know you're extremely diligent in that regard. So that's my 2 cents.
All right. Senator Weber Pearson.
Thank you, Chair. Want to thank the author for bringing this bill forward. I think that we are witnessing some very concerning things on a national front in a variety of spaces, but specifically now within our LGBTQ plus community. And not a lawyer, but as a physician, understand the harm that certain non-medical based practices like conversion therapy can have on individuals at a very young and very vulnerable age. So I thank you for tackling that and want to thank those who have come and revealed their stories. It's extremely personal and it's extremely difficult to talk about, especially in front of a bunch of strangers. And so I want to thank you all for coming out and talking. I'm wondering if, because I was, sitting here a little confused by some of the opposition, and we definitely don't want to cause any harm or any confusion within the health professional community. So I'm wondering if some of the concerns that are being addressed are on how certain things are defined, the new definitions within the bill. And I don't know if maybe someone who spoke up in opposition could come and clarify that. I think there was someone who,
I think that my concern is developmental with children. I don't think people are born with identities that emerge like a chia pet grows fur. I think your identity is something that is accrued over time through the values that you're raised with, through your personality traits, et cetera, et cetera. So I just don't think you can ring fence as sacrosanct the identity claim of a child saying that their identity is something not in their body. They're identifying with something in the ether rather than something grounded in themselves. And it may be true. 10% or so of the kids that had these concerns many years ago still had them when they reached adulthood, but 9 out of 10 outgrew the hatred of their body, and most of them were gay. So this is my concern. When you ring fence TQ identities and LGB identities, the Venn diagram radically overlaps. And a lot of other mental health disorders like foster youth have, dissociation, self-hatred, that kind of thing can give you a lot of repressed emotions, can give you somatic issues, aching stomach, et cetera.
Yeah, I understand all of that.
That make you feel bad in your body.
Well, I guess my question is, where specifically in the bill are you having a concern with? Like,
I'm concerned that in retrospect, a person who went to an ethical therapist who asked them ethical questions about their gender identity or their homosexual identity and who changed their mind could circle back later and say, if you wouldn't have changed my mind, I'd be happier.
Okay,
so that's risky.
So this is the confusion that I know I'm having and maybe other people are having because conversion therapy, and you can correct me, is already illegal here in California, correct?
Correct.
And there is already kind of like a statute out there where someone can.
It's an administrative enforcement against the therapist. It applies to licensed therapists, so it would be administrative enforcement.
And so this actually just extends the statute and
Yeah,
when someone can seek.
So
Just a minute, I need for him to clarify.
So no, it's a different approach because we in 2012 this legislature passed the ban on conversion therapy from licensed mental health professionals. The U.S. Supreme Court has ruled that the Colorado law, which is not identical to our law but is similar, is subject to strict scrutiny. And I know a lot of people who are smart people are figuring out what that'll be litigated back when it goes back down to the 10th Circuit. There could be changes to the law, to et cetera, et cetera. And I, frankly, in my view, even under strict scrutiny, I think the state has a valid argument. But this is a different approach. We don't know if our law will end up being enforceable or not. I hope it will be. But if it's not, this will ensure that there is still accountability and an ability to seek justice. And Justice Gorsuch, in his majority opinion, specifically said that malpractice claims are different than a ban. So we are taking this approach.
Thank you. And so my original question remains, is the concern from the opposition the way in which certain things are defined?
Yeah. Laura, can I speak?
Yes, sir.
Yeah, good afternoon. Again, Matthew McReynolds, constitutional attorney from Pacific Justice Institute. There are a number of concerns here, and I'll try to just address them briefly. Ours was the first organization that filed suit and got a preliminary injunction against the original bill, SB 1172, that we're talking about expanding. Many of those arguments from 14 years ago were ratified last week by the Supreme Court in the Chili's versus Salazar decision. And so if you read the press release that was put out about this bill, if you read the findings and declarations, I think what you see is the potential for this body to yet again give the middle finger to the Supreme Court. The press release refers to it as an extremist Supreme Court and goes after it. And that's the body that is going to once again have this litigated up to it. We and others are eager to take this on because we have a fundamental disagreement with the senator about the strict scrutiny standard. We have litigated that on and off for the last 14 years now. We're very, very familiar with it. To the other concerns that were expressed, this is not a simple extension of existing law. And existing law has been really put on thin ice by the decision last week. We think it's highly vulnerable, and challenges will be filed within the next month or two against it. So this is an attempted end run around the Supreme Court, and like many other similar measures that this legislature has taken in the last several years, many of which we've litigated, we think it's ultimately destined to fail.
Thank you. So I've been asking for specifics within the bill, within the language. I've been asking to specifically point to where is the problem. Is it how something is defined, because I do see that we have specific definitions in there, because I'm trying to help with Senator Ashby was talking about, Senator Wiener sitting down, but I'm not hearing anything specific. I'm hearing it more on a philosophical, theoretical, and that is problematic for me because when you stand up here and you say this is potentially going to harm children, this is potentially going to obstruct the ability for a provider to practice, that means a lot to me. And if you can't show me where in the language it would do that, then I feel like my time has been wasted because I'm asking you where, and I've asked a couple of times. So I thank you, Senator, for bringing this forward, and I'm done with my questions.
Ready? Thank you. Senator Lielo.
Thank you. There's been an expression of confusion, and I think it's because the bill is about the statute of limitations, but the discussion is a philosophic one relative to the treatment of gender dysphoria, particularly among minors. And on that point, I would point to the Cass report from the United Kingdom of a few years ago that condemned conversion therapy, for sure, but issued a strong caution, particularly relative to treatment of minors. First of all, a question. What is the statute of limitation for gender confirming care?
For the statute of limitations for what? For what legal cause of action?
If someone was to decide to change their gender, particularly if they're a minor, and that was accommodated via therapy, hormone treatment, or even surgery, and then subsequently a transitioning where there was an allegation of harm, what's the statute of limitation for that sort of action?
So, and just to be clear, when physicians or providers perform gender-affirming care, and once again, the vast majority of trans-identifying kids do not even ever receive a diagnosis, and an even tinier percentage receive even hormones or puberty blockers, and almost none receive surgery. And the ones that do, of that tiny microscopic number that receive surgery, overwhelmingly they're probably they're like 17-year-olds. So this whole notion, like that President Trump said in the presidential debate, he'll leave in the morning and come back with surgery in the afternoon, that's just completely made up. The people, kids or otherwise, who are receiving care, there are medically accepted standards for doing so. I understand that there are discussions about those standards, and that is totally normal with any form of medical care. And that is subject to normal malpractice claims if someone does not follow the accepted standards of care, and that is a 3-year statute of limitations, which is the standard malpractice. Here, conversion therapy, it is not accepted by any medical standard, and it does harm that manifests many years later. And so we think these things are very different, and they are not the same. And so we're focused on conversion therapy, which this legislature outlawed in one way 14 years ago. We're now taking a different approach.
You confirmed my confusion because you spent most of your time talking about the philosophic issue, not so much the statute of limitations. And that's why I say there's...
Because that's been injected into this, excuse me.
That's why I say there's some confusion here as to exactly what it is that we're talking about expressed in the questions that have been posed. Now, conversion therapy, strictly speaking, where a kid says, I'm gay, and the parent says, I'm going to send you to a counselor to convince you you're not gay, the Cass report condemns that. Just about everybody does. But therapy's different. And if you have a situation where you said, I'm going to send you to somebody who is going to tell you you're not what you say you are, but you are something else, And if that's successful, that's conversion therapy. The problem is, I don't think it's that simple. The discussion between a therapist and a patient is between the therapist and the patient. And if there was a conversion as a result of going to a therapist to explore gender confusion, but it ended up being a conversion, who is to say that the counselor either did or didn't say, you think that you're this, and as we proceed on our therapy here, I'm going to convince you that you're something else. It's not that simple. I don't think that we would ever necessarily know that. Whether it could be proved conversion therapy ends up remain to be seen at a later date, depending upon a regret for a decision or action that had been taken way back when the therapy was given. And that's the concern about this. So, number one, there's a difference in treatment. You're saying they're fundamentally different things, but philosophically, they are among the same universe of disagreement that we have, particularly with regard to the treatment of youth, and legal remedies are being treated differently in this bill.
I don't think that's true. And
I understand that. That's part of the disagreement between what you're saying and what I'm saying. Yeah. Because part of the confusion, as I said, is grounded in the discussion is not about statute of limitations. The discussion is the philosophic issue of therapy for gender confusion, particularly among minors. Well, there's a great deal of disagreement on that particular issue, which I think was clarified and handled well by the Cass report, and those conclusions adopted by most of Europe, but not by the United States, continues to be a confusion here, a disagreement here.
Okay, just in terms of I think what you're talking about, the aspects of the Cass report you're talking about, which by the way is a disputed report, but
you say it's a disputed.
No, I'm saying there are people who dispute it, but also some of the European announcements and pronouncements that have come out is about physical care. It's about surgery, hormones, puberty delayers. It's not in any way about saying trans people don't exist. It's not about sending whether it's a gay kid or a trans kid to therapy to change them to be something different. That's not what Cass report is about. It's not what any of the European announcements are about, and that's why I agree with you that there has been some conflation happening here, because we've seen some of the public testimony today being effectively just about, in general, opposing any support whatsoever for trans-identifying kids. And again, they're entitled to their opinions, but that's what they're injecting into this debate, which is about conversion therapy, which does not have scientific support and which is harmful to children or adults.
I didn't hear any witness say that trans kids don't exist, that gay people don't exist. I didn't hear anybody say
about gay people.
Even close to that.
That's all right.
You are assuming that's what they mean.
I'm doing more than assuming.
Maybe you heard something different than I did.
Doing more than assuming.
And that's part of the confusion, because we're not debating here a statute of limitations, which is what the bill's about. We're debating here the philosophy, as I articulated a minute ago, and you and I have some fundamental disagreements on that, but I'm not saying that there's no such thing as trans kids. I'm also agreeing that actual conversion therapy, where the intent is to counsel a person who thinks they're one thing and convincing them that it's another, is wrong. But therapy, when one is confused, particularly a minor, is not wrong, but it could be conflated to conversion therapy depending upon what happened and depending upon what that individual thought 5 years later. And that's the philosophic discussion that's sort of underlying everything that we're talking about here. And there are a lot of people in the audience that are nodding their head at that. And that's what's creating the confusion, because the bill's about a statute of limitations. That's not what we're debating here. We have a difference in philosophic approach of the treatment of gender dysphoria, particularly with regard to minors.
And in terms of the definition of what's called in the bill change efforts, what we colloquially call conversion therapy, it is very tightly and specifically defined in the bill. And so that's what the bill is about. It's about conversion therapy or change therapy and a malpractice action for engaging in that debunked form of therapy.
The only way to prove that that happened is for a third person to be present during the therapy.
But then what?
Because therapy is a confidential process.
Yeah. And if you're, it sounds like you just said, Senator, if I may, that that you agree that conversion. I don't want to put words in your mouth. I think I heard you say conversion therapy is wrong, and the CAS support report said that it's wrong.
But counseling is appropriate.
No, but that's what right. But in order to pursue a claim or an administrative claim under existing law requires adjudication by a third party. That's how the law works. And so it's always going to be someone, whether it's someone from a licensure board or whether it's a court, looking at what happened and determining what happened and whether it violated the law. That's always going to be the case.
And as I said, not to be overly redundant, therapy is a private and protected activity. And the only two people who knows what goes on in therapy is the patient and the provider. And if it comes to a court case and it's a he said, she said kind of thing, I don't know where the court goes on that, because those conversations are protected.
And that's how malpractice claims. There are many forms of therapy-related malpractice having nothing to do with conversion therapy. You can go to a therapist who counsels you in a way that causes you to commit immense harm to yourself and is outside of professional standards, and then you can sue that therapist. And then it's the two of you who are the witnesses and their notes and whatever else, or recordings or whatever else. That is totally normal. That's how malpractice claims work, whether it's with a physical, dermatologist or with a therapist or a psychologist. That's totally normal. That's the way malpractice claims work. What we're saying here is that people need more time to be able to bring these claims, just like we gave more time to the survivors of sexual abuse, because sometimes it takes people a long time to be able to process the trauma that has been inflicted on them.
All right. Senator Durazo, then Senator Valderas.
Well, I want to thank all my colleagues for asking the questions, because my understanding now is much better. And I think it's going back. I think it's about malpractice claims and the time you would have to file the claim. We're not deciding here about anything else.
The other piece of the bill also has to do with the malpractice claim and making sure that the actual scientific evidence is what guides the claim. So that's also in the bill, but it's about the same, the malpractice. It's about how long you have to bring it, what the deadline is, and making sure that actual science is what guides the claim.
And right now, I'm sorry, if I could ask another question. Right now, that the science basis is not part of the law?
It is.
Is that a new thing that
It's silent, so we are, you would think that that's what would guide it, but we just clarify that in the bill.
Okay, thank you.
All right, Senator Valderas.
Thank you. So I do think that we can all agree that we want to protect individuals who would be harmed in any type of treatment or service. But I would love to ask, I think the bill does more than just extend the statute of limitations, though. And if I think someone from the civil, Jack was here from civil justice, if I could just ask for some clarification from you. So in your letter, can you please elaborate or explain significantly expands liability through extended statutes of limitation and modified evidentiary standards. Can you explain how this bill modifies evidentiary standards and what the impacts could be?
Thank you, Senator, and with permission to come up here and answer the question. Thank you, Chair. So CJAC has concerns with the expanded statute of limitations in general for civil liability purposes and ensuring fairness in the civil justice with respect to the existing statute of limitations. To your specific question on modifying evidentiary standards, this bill modifies these causation standards by allowing general causation to be established through expert testimony and permitting specific causation to be inferred from the evidence. That is in, sorry, apologies, I'm getting the exact section, but that is outlined.
It's section E.
Thank you, Author Senate Section E. We have concerns with that expansion of causation.
Okay. And can you also go into elaborate a little bit more? This bill also creates a broad new cause of action applicable to a wide range of licensed professionals and entities, including those alleged to have known or had reason to know of conduct. And I think this goes to Senator Weber's point of how this, if this does impact professionals, whether it's licensed or certificated, what that growth of liability may look like for professionals.
Thank you, Senator. Yes, we see this as a new cause of action to have an extended statute of limitations period for mental health professionals. To the author's previous comments on relating this to medical malpractice cases. So we see the extended liability there, and we see this as a new cause of action, which is why we do have concerns for that component as well.
Okay.
Let me ask, I'm sorry, Senator Valadares, were you finished?
Yes.
Yeah, right. Let me ask a question. You've now touched upon a nerve here with respect to evidentiary standards. So tell me, if someone goes to a therapist and says, I have schizophrenia, or at least exhibits schizophrenic symptoms, and the therapist says, you know what you need is an exorcism. I'm not going to treat you with any medication or talk therapy. I'm going to send you to be exorcised. And turns out that person suffers harm because that healthcare provider didn't provide anything other than a recommendation to go to see an exorcist. How is that evidentiary standard any different than what's proposed in the bill? I mean, it's the same kind of evidence. You're right, you have to show causation. So I'm now very curious as to how this somehow changes the evidentiary standard for causation.
Thank you, Mr. Chair. We have concerns with the type of, as you just stated, the type of testimony allowed here to cause causation, to specify causation here and establish that. In terms of, I would hope that the standards of reasonableness to testimony allowed in a courtroom would apply if there are claims in that nature, as you said, as well. We'd be happy to dive deeper into the specifics and find a nuance.
Yeah, I would like that, because if this is changing evidentiary standards, that's something that comes within the purview of this committee, and I don't think it does. I think it remains the same. I think you still need, and I'm going to ask the author in a second, I think you still need the same causal connection, and you still have to prove it by preponderance, and you still have to prove that they fell below the standard of care. And I think that's exactly the same for any other behavioral practitioner. And I understand you're saying it's not, so I would be interested in finding out about that. Let me ask the author.
Yeah, and I actually, if the chair would like, I can ask Mr. Stoll can also talk about these issues with the National Center for LGBTQ.
Well, do you think it changes evidentiary standards?
No.
Oh, okay, all right. Well, if you don't think so, then is he going to come up and say he doesn't think so?
I would like for him to talk even in more detail about that.
Sure. Okay.
So, Senator, I think it's important to recognize that we're talking about here the same claims that survivors of conversion therapy can bring today, as long as they're within the time limitation period. It's just extending the period of time for them to do that. And with respect to evidentiary standards, I think it's not creating any new standard. It's just clarifying that the same standards that the California Supreme Court has recognized, for example, in cases of latent injury arising out of asbestos exposure, has recognized that a survivor doesn't need to establish that a specific manufacturer's specific product caused a tumor on a specific date. They just have to present evidence of the known scientific effects of exposure to asbestos and prove to a reasonable degree of medical certainty that that exposure was a substantial contributing factor to their injury. This is just applying the same sort of evidentiary analysis and making that explicit in the context of conversion therapy, which has the same kind of well-known and well-documented harmful effects on a population-wide basis.
So I think what you're saying, the answer to my question is no.
The answer is no.
Okay. All right. Senator Weber Pearson.
Yes, thank you, Chair. I wanted, if you could come back up, because you had mentioned two things, evidentiary proceedings, and then you had specifically mentioned something around the actual providers themselves.
Thank you, Senator, through the chair, if I may. In terms of the specific providers themselves, that was what we see as a new cause of action against mental health providers established.
That does not exist today?
Yes.
So someone.
Our reading.
Right. I wouldn't call it a new cause of action. It extends the statute of limitations, and it clarifies evidentiary standards. I wouldn't call it a new cause of action.
So why would you view this as a new cause of action that's not already established for providers in this, behavioral health space?
We see this as a new opportunity for claims to be revived also, and just in general, we do have concerns with that just from a standpoint of fairness and civil liability, and want to respect existing statute of limitations.
Are you saying because
cases,
it extends the time period? Or?
For that, and I apologize, Senator, I would be very happy to dive deep into this with the author's office and you and your office at any time that you would like to get you the specific answers. And I want to be really clear in our answers to that, if that's okay, Senator.
Yeah, that would be very much appreciated. Thank you.
Thank you.
There are no further questions. Senator Wiener, would you like to close?
I think we've discussed this at length, and I appreciate the conversation. And fundamentally, this is about making sure that people who have been harmed by this extremely debunked form of therapy that is absolutely psychological torture, trying to turn someone into something that they are not. People should have an ability to get compensation, and there should be accountability. I respectfully ask for your aye vote.
All right. Need a motion. Senator Reyes has moved the bill. All right. Thank you, Senator Wiener. Chief Counsel Estrada, would you call the roll, please?
There we go. Okay, this is SB 934 by Senator Wiener. The motion is due pass to the Senate Appropriations Committee. Umberg?
Aye.
Umberg, aye. Nilo? Allen? Ashby? Aye. Ashby, aye. Caballero? Durazo? Aye. Teresa I. Laird. Reyes. Reyes I. Stern. Valadares. No. Valadares no. Wahab. Wahab I. Weber Pearson. Weber Pearson I. Wiener.
Aye.
Wiener I. You have 7-1 with members missing.
7-1. All right, we'll put that on call. Thank you, Senator Wiener. And I saw Senator Arreguín here. Is he hiding somewhere? No. Oops. No, he's chairing housing. And Senator Becker, Senator Blakespear, Senator Allen, Senator Durasso. Calling one, calling all. She had to go to housing. Well, anybody have a bill for the 14th they'd like to do now?